We are recording tonight's session. Good evening. My name is Mercedes Witowski. I'm the Executive Director at the New Jersey Council on Developmental Disabilities. I'm also the parent of a young woman with multiple disabilities, and I want to welcome you all here this evening. Thank you for those joining us tonight, and for those that were with us last week, welcome back. We hope that you will not have any interruptions this evening with thunderstorms, but if you do, please just log back in. We'll be here, hopefully all moving forward. There's no question that these have certainly been the most challenging times, but we are fortunate to be able to support you through some of these difficult hurdles in the last 14 months. I know that I'm speaking to the choir in saying that nothing could have prepared us for the many, many impacts of COVID-19 in the lives of our loved ones with developmental disabilities, and the families that are supporting them, or the systems that support them. So I want to again welcome you tonight on behalf of the New Jersey Council on Developmental Disabilities and our strong colleague at SPAN New Jersey for their partnership and leadership, and the many, many fierce advocates and advocacy organizations for students with disabilities. We are here once again to talk about S-3434 and A-5366. These bills have passed unanimously with bipartisan support in the Senate and Assembly. Senate Bill 3434 was sponsored by Senator Steve Sweeney and Senator Dawn Addiego, with an identical Assembly bill sponsored by Assemblywoman Valerie Huddle, Assemblywoman Pam Lampett, and Assemblyman John McKean. The bill is now at the governor's office for signature, and in our collective hands to advocate that the governor sign this bill, and that eligible students, with the support of their families, they have the resources and tools to participate in New Jersey's progressive response to fill a much needed gap in the educational supports and services brought about by the COVID-19 pandemic. Last week, when we thought we had recorded all the questions on your mind, we quickly realized in the course of our time together that there were many more questions. We still may not have all the questions and certainly may not have all the answers, but we are committed to seeking answers and bringing you the necessary resources to manage your way through the days ahead. Tonight, we will recap what you can do to make contact to get the bill signed. We'll provide you with information that we've assembled and bring to you a talent group of attorneys to spend the next hour plus with you to best troubleshoot your questions and respond to your comments. On behalf of the New Jersey Council on Developmental Disabilities and its Public Policy Committee and Children and Youth Subcommittee, along with the evening's town hall supporting organizations, thank you for joining us. Thank you to our panelists for taking the time to be with us this evening. Much of this has happened very, very quickly, and we are so grateful for your rapid response. We've come a long way in these past months, but we know we have many more challenges and opportunities ahead. But together, and I underscore together, we can do all that we can do to help students and their families. And we must look forward, and we must look at ways to make things better. There really is no alternative. We're going to ask you to use the Q&A feature tonight on your screen. It should be toward the bottom to post any other additional questions or comments. We will get through as many as possible. We will not be using the chat feature tonight, except for our staff to share links and other important information and resources, as well as the panelists to share things that they can put into the chat. Tonight's session, by way of reminder, is being recorded. The materials and the recording will be available, as was last week's session, and the recording was emailed to everyone who had registered. So check the email address you used to register. As quickly as we can, we will get you a recording, and we will get you any of the materials that we present this evening. So I'm going to turn over to help us through the presentation and moderating the questions. and want to thank right now Brenda Considine for your inordinate amount of work in the last week, and your tireless effort, and for leading us here tonight. Brenda?
There we go. Let me unmute and welcome everyone tonight. Mercedes, thank you for that introduction. It is an honor to be back tonight. I wish that I was kicking us off with good news that the bill had been signed. As of now, our opening slide tonight is a take action update. You'll recall last time we closed with that slide. A week after the passage of the bill in the Senate, as Mercedes pointed out, S-3434 remains on the governor's desk. And so families who are interested in taking action on the bill, who want the governor to take action, should email his office. We got feedback after our last meeting that the phone lines we had provided were going to a voice mailbox that was full. So we were really trying to emphasize email, and I know some families had faxed. So I'm thrilled to see already that we've got 3 questions coming in. Last time we ended up with 201. So we will do our very best. Tonight's forum is primarily a Q&A, but for those of you who are joining us for the first time, I wanted to introduce tonight's panelists. I've got Peg Kinsell right at the top. Unfortunately, she was not able to join us tonight, but asked that I bring greetings. I'm going to be using her slides to provide a basic overview of the law. For those of you who were here last time, some of that will be repeat, but for those who are new tonight, it'll be helpful, I think. Mercedes Witowski, Executive Director of the Council on Developmental Disabilities, and our attorney panel, who I just cannot thank enough for coming together tonight on very short notice to do this Q&A for families. Let me welcome Liz Athos, an attorney with the Education Law Center. Liz, you want to give a wave? Okay, there's Liz. Rebecca Spar with the New Jersey Special Education Practitioners and also a board member at the Education Law Center. Rebecca, you want to give a wave? Okay. Denise Rekem of Parles Rekem, you want to say hello? Give a wave. And Katherine Reisman of Reisman, Carolla, Gran, and Zuba. And these 4 attorneys have really been watching this issue, communicating back and forth, doing a tremendous amount of legal research because of the nuanced nature and uncharted nature. You know, before you guys got on, we had a little bit of a discussion about how this is very uncharted territory. So you tonight have the benefit of 4 of the finest legal minds in New Jersey as it relates to this topic. So you're in the right place. Let me advance my slide on here and just very quickly do a basic overview of what S-3434 is. S-3434, as Mercedes said, has passed the Senate and the Assembly. It's on the governor's desk. The bill would require boards of education to provide special education and related services to certain students, and certain is an important word here, we're going to dissect that, certain students exceeding the age of eligibility for special education and related services. That's the top level language of the bill. So now you've got sort of a sense for what that bill does. When we get a little bit deeper, we start to ask some questions. Who's eligible for the added year of special ed? The first group of students who are eligible are those who turn 21 in this school year, meaning those students who would age out, turning 21 before June 30th. Those students are age eligible under this piece of legislation. The next group of students who are eligible are those who will be turning 21 next year and the following year. So students who are now 19 and 18 or who will be turning 21 or aging out in the subsequent school years. Those students are eligible. They will not get that extra year now because they're still eligible. If eligible later, they would get that added year at the end. We're going to talk a little bit about some of the data keeping and record keeping that families in that situation might want to consider now so that we can start to document whether or not the student actually has experienced any losses and whether or not the student in fact needs compensatory ed or additional services. One important point that came up in our discussions was This is not automatic. Not every student who turns 21 is automatically eligible for an extra year next year. It's subject to the IEP team agreeing that the student needs additional or compensatory services. And what those services are is an IEP team decision. And we're going to go into a little bit more detail about what that means as well. So our questions are up to 5 already, which is great because I will be prepared to turn those over to our attorneys. So families have asked, what services can be provided under S-3434? And the answer is additional or compensatory services. It's a very broad definition. The services are IEP driven, which means that they have to be put into the student's IEP in order to be provided. They can be full programs, related services, and transition services, such as community-based instruction. We can go into more detail if people have specific questions about the services. The law says additional or compensatory. So that means that new services can also be added to address regression and mental health issues that may have come up during the pandemic. The next set of questions we often got were, how are these services funded? The first thing that's important for you to know is that parents cannot be asked to pay for these services if the child is eligible. The same guarantees that protect you and your child under federal law now protect your child under this piece of legislation. The program is meant to be funded through 3 federal programs that were set up to address the impact of the pandemic. And some of that money is earmarked for kids with disabilities. The law says that if the funds don't cover the costs, the state will reimburse school districts. And so parents often ask, what do I do first? The first thing we're urging you to do is make your wishes known to Governor Murphy. There is no legislation right now. There is no law. Our attorneys are going to talk about what that means anyway, because there's the belief that many of our kids are likely eligible for compensatory education and additional services, but our attorneys will answer that. Decide what you think your child needs. It might be that even if the bill is signed, you sit back with your family and you say, you know what, we're ready to go on to DDD or DVRS. DDD being the Division of Developmental Disabilities, which serves adults. DVRS being the Division of Vocational Rehabilitation Services that provide job supports. So you might decide that even with the pandemic and even with some interrupted services, that your son or daughter doesn't need any additional special education services. Last time we learned that it is possible for students to benefit both from DDD services and some special education services as long as they don't duplicate each other. So we had a guest speaker last time from the Division of Developmental Disabilities who clarified that point for us. So we make our wishes known to the governor's office, decide what you think is right for your son or daughter, and then take action with your school district. And that last statement is very broad intentionally because that action I'm going to let the attorneys describe. So without further ado, I'll just frame some of the key issues for questions: eligibility, determining the range and scope of services that your child might need, compensatory education in general, whether the bill is passed or not, placement program services, timelines, graduation and diplomas for 2021, and disputes and disagreements. I'm going to pause for and the commenter suggests that continued pressure is essential. So it did come up, and that was the response.
So Brenda,
the bill is under consideration.
You may not have been heard in that last segment. So you just want to just repeat that last section?
Sure. One of our commenters, instead of, it wasn't a question, it was a comment, indicated that the governor did respond to a question about this during his press conference today. So his answer was, and this is the person quoting him, "We do not comment on bills under consideration." And the commenter says continued pressure is essential. So we do know that the governor's office is considering it. So those are the general categories of the types of questions that we had last time. At this point, we have got 10 questions already brewing. And I'm gonna turn it over to our attorneys because this is why you're here tonight. Liz, do you wanna just introduce yourself, say hi? And I'm asking each attorney to open with what they think is one of the most important action items you can take at this point, and then I'll dive into these questions. That'll give me a minute to look at our questions too. So Liz, you just wanna introduce yourself and suggest what you think parents are gonna do?
Sure. Hi, I've been an attorney at Education Law Center for over 20 years. We're based in Newark. We do done funding issues for years and have a student rights project. We do both general ed and special ed cases, special ed in the northern and central counties. And, you know, we're working right now with Volunteer Lawyers for Justice. We'll try and put together part 3 of this webinar to, you know, really provide a deeper dive for people who actually have to challenge what their school districts are doing. But I guess, you know, one of the important things to focus on tonight is that your child likely has rights to services, whether or not this law gets passed. You know, obviously we hope the law gets passed. It's a good policy decision, you know, for that to happen and make it clear that there's, that we want kids' services to be extended. But, you know, we're going to talk about compensatory education in general, even if the law is not passed.
Thanks. Thanks, Liz. Rebecca, do you want to just say hi and give us your top level action step?
Okay. Hi, I'm Rebecca Spar, and prior to leaving Coleshots in 2018, I handled a number of special education cases. And since then, I've done volunteer work with Volunteer Lawyers for Justice, and I'm on the ELC board and the New Jersey Special Ed Practitioners. I think that a couple of things that I would suggest parents do is if you want to participate or want to get additional services, compensatory ed for your child, don't accept the diploma. If you've already accepted it, you may want to notify the district that you are not accepting it at this time, because once a child has a regular diploma, which is the only kind of diploma that New Jersey offers, then the child is no longer entitled to special ed. The other thing that I would suggest, if this bill is not signed before, and even if it is signed, but the district hasn't agreed to provide anything, I would suggest that you file due process before the student graduates. And filing due process is not complicated. So, but once you do it, it invokes what is called the stay put, or the district has to maintain the status quo while your due process is being decided. So if you do those two things, then you can protect and make it easier for your child to hopefully get services, either with this statute or through Comp Ed in another way. If you've already accepted the diploma, you can unaccept it and say you're not accepting it at this time. It's not that you're giving it up forever, because the district will give it to your child whenever you know, the dispute is finished, or whenever you say that you want it now. So.
Okay, Rebecca, thank you. Thank you for that good advice. Denise Rekem, you want to introduce yourself and give your top level tip?
Hi, everyone. Nice to meet everyone, or to be on this panel. My name is Denise Rekem. I'm a partner at the firm Parles Rekem here in New Jersey, and we represent families in school district issues as well as adult service, DDD type issues. I think Rebecca's points are excellent. I would second what she said. I guess I would add that putting in writing, you know, not in lieu of, if your child is going to graduate, I agree with Rebecca, you should file for due process. Just, you know, even if you just file the form, you say your child did not receive FAPE, their free appropriate public education, because of the COVID pandemic and denial of services, and that you're requesting, you know, appropriate services and compensatory education. It doesn't have to be, you know, a whole big thing. And someone asked about filing for due process, and I did put the link to the page on the Department of Education website in the answer. So I'm assuming that was shared. But I think, you know, in general, even before you get there, you want to put in writing what your child missed out on. Your child was supposed to be in a program that was in the community, and they were not in that program in the community because of COVID for months at a time, really sort of laying out the deprivation of what was in the IEP, what was supposed to be provided and what was not provided, and, you know, the impact that had on your child, and putting that in writing and giving it to the, you know, case manager, hopefully, if you haven't had those IEP meetings prior to the IEP meeting. And if they tell you in person, you know, in the meeting, oh, we're not going to do this or that, you want them to put it in writing. You want them to respond to your request in writing with a reason why they're denying what you're asking for. You're entitled to that, and it's an important, you know, piece of evidence for you to have. So that would be what I would add.
Thank you. And Katherine, do you want to introduce yourself and give us your top level tip?
Okay, my name is Katherine Reisman. I'm a partner at Reisman, Carolla, Gran, and Zuba. We are in Haddonfield, New Jersey. We represent students throughout the state of New Jersey. And I obviously echo what's already been said. My top level tip was going to be what Denise said, which is have the data, have the data about what your child didn't get. Was it that, you know, speech teletherapy didn't work, so they missed 40 sessions of speech? That kind of thing. Know exactly what it was that was not provided. The other thing is that the compensatory or additional services, whether we're talking about under this bill, if it gets signed, or compensatory education, if it doesn't get signed and we're talking about that, the guidance says the IEP team is supposed to determine the need, type, amount, frequency, and duration. So if you go into an IEP meeting and you get a draft of an IEP that says for compensatory education, we're going to give 30 extra hours this summer for ESY, and you don't think that's enough, you should document that you're not accepting that amount of compensatory education that's been unilaterally decided on by someone, you know, you don't even know whom, you're just getting a draft of a document. So you are just as much involved in this process as you are in any part of the IEP process. And that's why arming yourself with data and making sure that you know what it is. I think you had that in the beginning, Brenda, know what your child needs. And you know, you're still part of the process, and you haven't given up that right. Even if this bill isn't signed, we'll talk some more about that in the Comp Ed situation.
Okay, thank you. Thank you.
Brenda, I know last time one of the questions was, what is Comp Ed, Compensatory Services? So maybe, I mean, compensatory education is to either make up for an IEP that was not appropriate in the first place. But here in the pandemic, it's usually because an IEP was not fully implemented or was not implemented in a way that was appropriate, sometimes because of the COVID, because they're virtual and so on. So it's to make up for services that should have been provided by the district according to the IEP, but were not, or to make up for regression, as Denise talked about, where you've lost skills or you have new issues because of what happened during the pandemic.
Thanks. I think it's really important to start with that framework so people understand what these terms mean. Appreciate that. So we've got questions. I'm going to ask Kyoko first to launch our first poll, just so we can get a sense for who's here tonight. We've got 141 participants. Kyoko's going to launch a poll just asking, who are you? What brings you out here tonight? So that you should see that poll pop up. And there we go. Okay, so with almost 3 out of 4 of you having answered, we've got a little more than 100 responses in. I'm gonna end the poll momentarily. We asked who you are and how old your son or daughter is, and here is what we learned. We learned that about a third of you have young adult children that are about to graduate this year. We learned that about 22% of you have a student under 21. About 3% have even a younger student. 22% of you are school leaders and child study team members. And 25% of you are advocates or other. We asked, have you asked your school district about this yet? And about half of you have, half of you haven't, and about a third of you have it wasn't applicable. So I just want to stop for a minute. One of our first questions is actually from someone who serves on a child study team. And that person asks, I'm a member of a child study team. As such, can I suggest this option to the parent, or do the parents have to request it? And I guess we'll start with Liz on that one.
Sure. You know, you'll be meeting as an IEP team. You know, absolutely. I think a school district has an obligation to suggest what services it believes are needed. You know, when a child, if you think there are additional services that are needed, you should make the parent aware that they're out there, and you know, talk about them. You should bring the parent in for an IEP meeting to talk about exactly what the child needs.
We do have tools. Also, we've got a fact sheet and an article on NJ Common Ground, which is a project of the council. And as a follow-up to this event, we'll be emailing you this video and those tools. And so if you wanted to share those with the family, you could do that. Next question says, what if I think my child only missed out on transition services? Will the additional year be part-time? And we'll ask Rebecca to answer that.
You're on mute.
You're on mute.
It's up to the IEP team, of which you are a member, the parent is a member, to decide what the additional year would consist of. So it could be that everybody agrees that it only part-time, a certain number of hours of services or a half-day services. And it could be, the decision would be that it would need to be a full day and for the full 12 months. So it's up to the IEP team. Another important part of the law is that the parent has all of the rights, if this statute goes into effect, that a parent would ordinarily have to disagree with IEP team decisions. So you can file mediation, you can file due process or a complaint investigation if you're in disagreement with what the IEP team decides.
Okay, next question, this will be for Denise. Someone asks, what is the best way to request vital transition services if you're not requesting another year of school? Have districts set a precedent awarding ABA hours, etc.?
Okay, so I think that it's all sort of wraps into the same thing, that you have, as a parent and also as a school district child study team member, you have to look at this individual student. What was in their IEP? What were they supposed to get but for COVID? Again, this is, an interesting situation because it wasn't really anybody's fault that certain things didn't happen. They couldn't happen if things were closed, or if the person was supposed to have in-home ABA hours and nobody could come into the home because of COVID, or, then obviously they didn't have those hours. So you don't have to request a whole other year of school. You can say, my child missed these services, that you've documented, that because they missed those services, they weren't able to learn the skills that those services were supposed to provide. And you're asking for compensatory education. So they're sort of, you don't have to say, I want my child to be in school again another year. You can just say that these are the services I believe my child needs as compensatory education to make up for the deprivation that they experienced in the past year, over a year, because of COVID. I would just throw out there, because I did see there are quite a lot of people that work for schools. And I think that this is a really important time for parents and schools to be collaborative with each other, to be looking at each child, and really what was envisioned was that the school district, not that the parent was going to have to come and request things, but that the school district, who knows what services were supposed to be provided and what couldn't be provided. Again, this is not a fault situation. And then have this meeting, and the school is actually supposed to propose what they believe, what the team believes, or at least a starting point, right? Just that like they propose an IEP, what they believe that it needs to be done for compensatory services. And then the parents need to talk about it and have what they think, and they come to a solution, just like how everything else works with an IEP meeting. So it's very important, for the districts to have those conversations with the parents, because like anything else in special ed law, not all the parents know what to ask for, or even that they should ask for anything. So I would hope that the schools would have those conversations with all of their families.
Thank you. Someone asks, my district has said that they will not honor another year, ! I filed for due process and I'll need help. In order to get my daughter into a school, I signed a settlement agreement and they sent her to a private LLC. They're saying they will not honor this extra year. How do I proceed? And that's a question for Katherine.
So without knowing what's in the settlement agreement, I don't know what rights your daughter does or doesn't have. What I can say is, in a situation where the school district at this point has said they will not give you another year, and you file, and the bill gets signed, you'll have stay put, and the services have to be in place. If the bill isn't signed, and I think that's what people need to understand, the difference between if the bill is signed, if the bill is not signed, stay put won't help you, because your child will have aged out, but you still would be, your child would still be entitled to compensatory services. If you're given a settlement agreement in connection with some of these requests for additional or compensatory services, I would definitely have an attorney look at it. I mean, it's impossible for any of the panelists here today to say what impact, you know, a settlement agreement has on a particular situation.
Thank you. So someone asks, is there a deadline by which the governor must sign this in order for our aging out kids to get that extra year? What if he signs after the 30th? And that question comes back to Liz in our round robin here.
Well, so the issue will be whether your child has graduated or not. As long as your child has not graduated, there is still the option of additional services if the governor signs the bill afterwards and you haven't already done anything. I mean, for this, a lot of our advice is going to be particular to students who have turned 21 and are aging out this school year. And, you know, we do think with graduations quickly approaching and the governor not having acted, that parents are likely have to file for due process before that graduation. I mean, that would be our what we recommend that parents do. And you know, and I saw one of the other questions was someone who's turning 21 on July 1st. You know, July 1st is a new school year. You actually, as long as your 21st birthday is after June 30th, you get a whole nother year of school. But for any student who's 21 before then, I mean, you still have the right to participate in graduation if you want to. There was Alicia's law that was passed that allows you to participate in senior activities, to participate in a graduation ceremony, get a blank diploma essentially. But you'll need to make it clear to your school district that you're not accepting the diploma if you're trying to get a continuation of services.
Liz, could you just expand a little bit and talk about when the parent should file for that extra year if their child turns 21 next year, and what they can do now to begin to document whether or not, you know, regression or lost skills have indeed occurred?
Okay, I'm sorry, you're asking me if they turn 21 after June 30th, like the child who turns 21 on July 1st or later?
Yes, yeah. The second half of her question had to do with when should I request that extra year? And then we were talking offline before we started about how do we document? Because it's not automatic. We have to show that there have been, you know, lost services or losses. We have to show that it is needed. So how would they document that, and when would they then ask for the services?
Right. So there's not, you know, there's not the same immediacy of having to file for due process if your child is not turning 21 until next year, because they will still get the full other year of services. And the federal government has invalidated New Jersey's practice of saying you can only get state put if you file within 15 days of getting a notice. So, you know, I think what you still need to do is start the process with the IEP team, send the request about having the meeting to talk about, and you should be able to get service logs from the school district if that's an issue about, you know, to what extent services were provided. ELC has a FAQ about COVID-19 and students with disabilities FAQ on our website. that talks some about compensatory education and talks about documenting services, whether the need for services, whether it's by videoing your child and what they're able to do over a period of time, or you know, gathering progress reports, and there's a sample log at the back of that FAQ that may also be a way to help keep track of.
Great. We'll make sure when we follow up after today's meeting that we send a link to that.
Right.
Rebecca, do you have anything to add?
Right. Parents could also, in addition, they could request the logs, because related service and teachers during COVID had to submit logs. They can request those logs. If the district doesn't want to give them, you know, just by the parent writing a letter, you can also make a public records request. As the parent of the student, you're entitled to those records. And you can get them through Oprah, which has strict timelines, which sometimes becomes an issue. So you can also ask for any assessments that were done, copies of assessments, the progress reports, the any recordings that the teacher did of the virtual instruction can be helpful. I mean, and all of this could be done now, or at least in the next couple months, because, and then you would have it available when you needed it next spring.
Beautiful. So Rebecca, I'm going to let you answer the next question. It says, can you clarify what you mean by stay put does not apply if the child ages out? Can compensatory services be provided after a child turns 21 if the bill does not become law?
Okay, so the stay put, the federal and the state statute say that during any proceeding, which a due process is a proceeding filed under the special education statute, the student is to stay put in the current educational placement. And for those students who are aging out, there is no precedent in this circuit one way or the other, whether a student who is aging out is entitled to the stay put. So it's not correct that you can't use the stay put. It just happens to be an issue that hasn't been tested yet for students aging out. However, the courts in this circuit have said that the stay put is absolute, automatic, and applies with any proceeding. And if a parent is filing due process for a student that is aging out, there's no question but what that is, a proceeding. You definitely can file for due process if your student is aging out. So, you know, you have an argument that the stay put would apply, which allows your child to continue to get the services while the due process takes place. It takes far too much time for a due process to take place. It's not something that's going to happen in 10 days, 20 days, or 45 days. It's going to take much longer. So if you can keep the services that your child currently has, then it's a better situation usually. So the stay put maintains the status quo. That's essentially what it does. And I know parents, you know, are aware of it because it happens every year when the IEP gets changed, services are reduced, and parents know they have to file if they want to keep the status quo.
Okay. Denise, this next one's for you. What if the parent has had an exit IEP and during the meeting they agreed to what the district offered? In this case, it was ESY or a half year, for example. is there a certain number of days after the IEP that it could be nullified and the entire extra year can be pursued?
So I would say, you know, first of all, you can reach back out to the district and just say that you were unaware of this law, that you are not in agreement to what they proposed based on the fact that now there is this law that's been passed waiting for signature that, you know, would offer your child more services. I mean, it's hard to say if you agreed to what they offered because you believe that that was an appropriate amount of services. Again, as we were saying before, it's not an automatic that even if the governor signs that all the district IEP teams with the parents are going to say, well, this child really needs a whole other year of school. It still could be that, you know, given what they were able to get, you know, over this time. I mean, there's such a wild difference in districts, and some of the districts have been open for a long time. Other districts opened last month, basically. So there's a wide range. There's also a wide range of students that could benefit from virtual online instruction and others that couldn't benefit at all from online instruction. So I think it really is, as with everything else in special education, an individualized process. I wanted to piggyback on what Rebecca was saying, just to explain that even if you, I mean, I agree, you claim stay put, but even if the judge said, you know, we don't agree that you have stay put because the child is older, say this law, if it didn't get signed, now the child's aged out, you still can pursue compensatory education after the child has graduated. So that is still an avenue open. It doesn't, you know, stay put the student in that position during this process, but you still have a claim to say that your child missed out on whatever they missed on and that you're claiming compensatory services. And then if it's awarded, the child would get access. I mean, they'd have to figure out how to provide those services. It might be in a different way than they were provided before because they're not in school anymore, but it doesn't mean that you can't pursue the deprivation in the comp ed, even if they've graduated or you don't have stay put.
Okay.
Can I just, Brenda? Oh, sorry.
Yes, please.
Can I just add to something Denise said, just to make it clear, if you've signed an exit IEP and you've changed your mind, you know, Denise said to reach out to the district, and absolutely I agree with that, but I just want to suggest that you should put it in writing as well. You know, I'm sure that I don't know, she might have said it, but I just want to emphasize that, you know, it should be in writing, and there is a regulation that says you have the right to revoke consent at any time. So you can revoke your consent. Just wanted that to be clear.
Yeah, I think the put it in writing lesson is one that I know I learned early on when my son was in special ed, that write it and date it were my two mantras. Katherine, this next question is for you, and I'm going to first frame the question and then open it a little bit broader. This is from a self-disclosed student who is now 21, and he writes, what happens if my school district doesn't give me a list of services? Are there other services? He asks specifically, what about vision services? And so this question, I think, begins to get to, what can I get through this? What services might I need?
It would cover vision services if that was something that the student needed and had missed out on, and you could show that there was an impact on that. What you can get and what is going to be, again, we keep saying this, but that's the nature of special education law. It's very individualized inquiry. So you have to look at what the needs are from what services didn't you get during the pandemic, and what services do you need to make up for that? And it would include any service that you can get through the IEP in the ordinary course. So it could be ABA services, it could be speech, it could be physical therapy, it could be travel training. It just depends on what the student needs. And that's determined by the parents and the IEP team.
Thank you. Someone asks, should students walk in graduation if they attend an approved private school if the ceremony occurs prior to the signing of the bill? That question would be for Liz. I'll put in parentheses here that many private schools give students a certificate of graduation. Not all hand them the actual school diploma. So if we can talk about the nuanced differences between those two things as well in answering this question, I think that would be great.
Sure, and I don't see any, I don't think there would be a problem accepting a certificate of completion from a private school that's different from an actual graduation diploma, you know, a state endorsed diploma. You know, the student can walk in the ceremony regardless. I mean, just make it clear that you are not accepting a diploma for graduation and invoking your child's right to participate in a ceremony, but without, you know, should not be offered the graduation diploma. And, you know, if somehow your child is given a graduation diploma, you can give it back after the ceremony. I think it's really more a matter of just trying to make clear in writing what your intent is with regard to your child's graduation. And, you know, actually affirmatively filing for due process if you're going to try and invoke stay put.
Okay. The next question is for Rebecca. Someone writes, my district agreed to extended school year and an additional year if the bill passes. If the bill doesn't pass, they won't consent. If the governor doesn't sign, what would my options be? Should I file for due process for Comp Ed? Interesting situation.
Well, I would suggest that you file for due process for Comp Ed unless the governor signs the bill before your child graduates. Even if the governor may sign it after the graduation, but I would file due process before, and you can request compensatory ed as a part of that, of the services. One of the things that I wanted to mention, because I've seen this in some of the requests for transition services, sometimes parents refer to those services as post-secondary services. And that is highly not recommended, because post-secondary means after you've left the high school. It doesn't mean after you've left 12th grade, it means after you've left the high school. And while you're under the rubric of the high school, you're asking for transition services. Don't call them post-secondary, because the court and the school districts tend to jump on that and say you're asking for types of services that you're not entitled to, that a school district doesn't have to provide. So call them their, you know, transition type services if you're going to lump them in a category.
Thanks. Sort of related to that, someone says if the law doesn't pass, could the district agree to keep your child for one more year, even if they are 21 already? I think you've pretty much answered that.
No, they can't. New Jersey regulations say that school districts have the option of continuing students past the year in which they turn 21. So there are two provisions for age. One says you have to continue them. It doesn't actually say till the 21st, through the year in which they turn 21. It says through the age 21. The student is eligible for services. And then there's a second provision that says any school district has the option of continuing students past through the year in which they turn 21. So it's already an option for school districts to decide that they're going to keep all the students. Now, they're not going to do that, but it's an option under state regulations to do that.
Rebecca, remind me at the end to get that citation from you so that when I follow up with families, we can provide them with that language so they know where to go. And not that any of you necessarily want to become, you know, young lawyers, but it is helpful to have those citations as you're arming yourself for advocacy. Someone asks, how will we know the final decision on the bill? Stay tuned. Obviously, if you have come to this event, you'll get a follow-up about if the bill is, someone who comes to this event also learns about the event that the special education practitioners are planning. I'm going to come back here. Some of you have very nuanced legal situations, legal settlements, and I think what we're going to end up with is 4 attorneys saying I'd have to see the legal settlement. So I'm going to hold those, and I apologize to those of you who have those nuanced questions.
Brenda, Brenda, I just wanted to do a little shout out to the Education Law Center has an excellent resource on your rights to special education. It's a book that you can download from the website that literally goes through everything and is cited to all of the parts of the law that are relevant to those sections. So I would, maybe you even want to, when you send your things out, to send a link to that. It's really like, it's written for families, it's comprehensive, and it's just an excellent guide.
Thank you for that. Yeah, I know we often talk about PRIZE, but I have often used Ed Law Center's guide. It is a huge resource, so we will provide that link as well. Does it matter if I chose to keep my child remote, even if the programs were open to in-person learning? And that question will go to Denise.
No, it should not matter, because you had the right under the governor's orders to, the families all had the right to choose what they were comfortable with as far as keeping their child's home, and that should not, and my position is that without, you know, I mean, they can try to say that made a difference, but I don't think they would have a successful argument that precludes the child from, you know, any services that they require.
Great. Catherine, someone says, if the bill passes, would there have to be a full IEP meeting, or can the parent just request in writing that the IEP is amended without a meeting?
If the bill passes, then all the normal rules about IEPs would apply to this IEP. So if it met the requirements for amendment without a meeting, you could ask for amendment without a meeting, and you could do it that way. I don't see any reason why it would be any different if the bill passes.
Okay. Someone says, is the district required to put compensatory services, the term, in the IEP and list it as a compensatory service? If so, where? Where in NJAC, that's the New Jersey Administrative Code, or IDEA, that's the Individuals with Disabilities Education Act, can I find the requirement for this? And go to Rebecca.
Well, it's compensatory education is not referenced in either the federal statute or the state statute or regulations. There is one place in the federal statute or the federal regulations which says that in a complaint investigation, the state Department of Education can provide remedies, including compensatory ed and monetary reimbursement. That's the only reference. Compensatory ed was created by the courts as a type of appropriate relief. And it really followed because the courts first allowed parents to place children privately and get reimbursed. And so then they looked and they said, well, parents who who don't have the means to place privately and wait to get reimbursed have no remedy. And so they created compensatory ed, the courts did. So it's a judicially created remedy. As far as what a IEP team would have to put in the IEP, they would, I assume, would describe, I don't know how you do it mechanically, because I know people use apps that, and I don't know how to put that in, but you would want to describe what the compensatory services are and how they're going to be provided, just as you would any IEP service. I think what you put in the IEP probably wouldn't vary, except you would say these are what we've decided are appropriate compensatory services.
Liz, I think I skipped you. I'm sorry. We'll back up. Someone writes, we initiated a request for an IEP and we had an attorney request an accounting of services our son has not received. However, the district stated they're waiting for the bill to be signed. Are they bound by standard response timelines?
Yeah, they are. I mean, the standard response timelines are, there's 20 days from a written parental request for a district to convene a meeting if they think a meeting is needed to answer the question, or to grant the request or deny it and issue an appropriate written notice that the parent could then use for an appeal. It really, the districts providing this kind of information, you know, accounting of services should not depend at all on whether the bill is passed. I mean, that's information that parent has a right to know.
Thank you. So the next question is for Denise, and this sort of gets to parent-school district collaboration. The attendee writes, my school got in trouble for sending a letter to parents about the bill. Why are districts not informing people? The district jumped in and sent a letter to families that the law is not passed. If the law is not passed in time for graduation, they will not recognize it. As of 15 days of letter, the student is graduated. How is that possible? I met with the superintendent and they claim that there's no guidance on the bill. And I think this kind of speaks to the very fluid, uncharted environment we're in, but I'll let you respond to that.
Okay, I mean, there's a lot in there. I think there isn't guidance. There also isn't a lot of guidance on how the district should deal with the compensatory education. And we're in a landscape where this is all so novel that there isn't even really, there's some guidance on general compensatory education, like what Rebecca was speaking about, but there isn't any guidance on what happens in a pandemic when schools close down for a year and students don't get served. There was guidance from the Department of Education, the Federal Department of Education, that there wasn't a waiver of free appropriate public education, that the IEPs that were supposed to provide services were still valid, that there was a recognition that some of those things were not going to be provided at that time, and that the schools were gonna have to come back when they could at the end of all of this and talk about compensatory education. I think as far as this letter to all of the families, I mean, first of all, if they're saying 15 days from this letter, you can consider yourself graduated, then you want, as Rebecca mentioned before, to file for process to prevent that from happening. I would say that, you know, I mean, the districts are supposed to be meeting and discussing each child's needs. And if they're making blanket statements about all students to everybody, they're treading a very dangerous line for themselves of predetermining what every student needs or should receive, which is not how this all works. It's you don't get like the dyslexia IEP or the autism IEP, you get an individualized IEP. So while some students may not require additional services, other students may, and if they're sending a letter to everyone, that's not a great thing to happen. But I mean, the superintendent is right, there isn't guidance, and we don't know if this is signed and until it's signed, it's not a law. It's just something that's passed, waiting for the which circles back to the beginning of how important it is that everyone on this call emails and calls and gets their friends and family to email and call the governor's office to tell the governor that, sitting on the desk will be the same as vetoing it, that this is time sensitive. And if it isn't signed in time, it's going to negatively impact many, many students.
Yeah. Denise, I just want to underscore a point that you made. You said not only should we be writing letters about our wishes, but your friends, your family, your extended family. This is a situation in which numbers are going to make a difference. And we'll talk at the end about how to take action. Somebody said, I tried to leave a voice message and the mailbox was full. Yes, we know. And the best way right now is by email, by fax, and social media, but we'll talk more about those strategies at the end. So the next question is for Katherine, and these are two questions that really center around, seem to be having a hard time here with my PowerPoint. Two questions that really kind of go back to, oh my goodness, I'm having a, sorry about that. So these two questions really deal with who's eligible. Question one is, my child turns 21 during the 2021-22 school year. Should a parent wait to discuss comp ed because in those years the child could essentially make up lost skills? Another parent says, if my child turned 21 in August of last year, are they eligible if the law gets passed or for compensatory education? I'm not following this whole age out thing. So Katherine, if you could just sort of dive into what 21 means and who's eligible here. And I'm going to try to fix my PowerPoint.
Okay, so let's start with, if your child turned 21 in August, then your child is continued to be eligible for services, irrespective of this law, through June 30th of 2021. And if the law is signed, your child will be eligible potentially for services, depending on if the IEP team makes a determination that additional services are needed. If the law is not signed, then Rebecca pointed out, if you filed for due process before your child aged out, you have an argument about stay put. But as she also pointed out, there's no case law for or against that. But stay put is a very strong right in our circuit. So if the law is not signed, then even though your child's aging out and would not be eligible for additional services in the normal course, he or she might be eligible for compensatory education. So it's either, sorry about the dog shaking in the background, either you're going to be asking for, you could potentially invoke stay put to say that the status quo could be maintained, or the bill gets signed and you get additional services through the bill, or you can, even if the bill doesn't get signed, you could still be eligible for compensatory education. So those are the three ways you could get additional services. If your child is turning 21 after June 30th of this year, so he or she's already, if your child turns 21 on July 2nd, they're going to be eligible till June 30th of 2022, no matter what. And what I would do in that case is keep the records of the services that have been lost and keep very good records on, whether or not progress is made or to address whatever impact has happened with those services for the next year. And then at the end of it, go and say, these are the goals that weren't met. These are the services that weren't provided. And as again, as Denise pointed out, this isn't a fault thing. Like, it's not anybody's fault this happened. I mean, it was unprecedented. And it's not saying that anyone did anything that they're culpable or guilty of, but your child still might need extra services. So I would keep very good records over the next year in terms of lack of progress, and also get the records for the services that were missed during the pandemic. Liz is right. I mean, whether or not the bill's signed, you're entitled to those records of the service logs, things like that. So I hope that was helpful.
Thanks. Next question is for Liz. Someone says, if I decide not to have my child walk on graduation day, can they walk the following year once they complete their program?
Is she there?
Yes, I'm here. I'm so sorry. I had minimized my screen to try and find, someone had asked about a site to the 20 days. I was looking for the code, and then I couldn't find the way to get my screen back and unmute. Can I ask you to repeat the question, Brenda? Sorry.
Yes, it was if my child doesn't walk this year, can they walk next year? If I opt not to have them walk in the graduation ceremonies this year and they receive services, can they walk next year?
Yes. I mean, the Alicia's law was to give the option of being able to walk with the class you had gone through to 12th grade, even though you were going to go on and receive transition services. But I mean, you get to do a graduation. I mean, if you put it off this year, yes, you should be able to walk next year.
Okay. So just a couple comments in the chat, moving us into the advocacy discussion. We will take a few more questions. One parent is describing going to social media to post the importance of this bill. If we opt to do that, I would encourage you to use a hashtag, the number sign S-3434. I doubt that we will trend. It's just, we're I think too small for that, but do use that hashtag. You can use the governor's social media pages. I do see a lot of discussion in private closed Facebook groups. Please know that those don't search. So if someone in the governor's office is looking to see, is there a lot going on social media about this, even though this closed group has blown up on S-3434, unless you're on a public page, those comments cannot be read by anyone who's not part of that group. So if you're looking to go social media route, make sure that you are commenting on a page that's public and hopefully a page that the governor or his staff are monitoring. Another parent says, is there another phone number we can call? If you know someone in the governor's office, reach out to them and call them directly, ask them if there's another number. I would be reluctant to, give a phone number of someone who wasn't charged with this task. And unfortunately, that's that constituent relations line that you've been given. Faxes are getting through, as are emails. You can also, we've heard from some families who have called their state senator to say, I can't get through to the governor's office. Can you call? So that's another another strategy. All right, so one parent says, I filed for due process and emergency relief. I was given a hearing date. I am doing this pro se. What can I expect at the hearing? What should I be prepared for? And Rebecca, this is yours.
Okay, it depends on the hearing date. Do you know for sure that this is an actual hearing date? Because sometimes OAL sends out notices saying that you've been scheduled for one date, and it's actually a settlement conference. So, and I don't know whether the hearing date that you're talking about is for, also could be for the emergent relief, which means it is probably an oral argument. I'd need to know whether it's for the emergent relief and whether it's a date that was sent out to OAL, which really is going to be a settlement conference.
Right.
But as a practical matter, though, if no emergent relief was requested, the first hearing date is always a settlement conference. It may be called a hearing in the notice, but the very first date is conducted as a settlement conference.
Right. I thought that Brenda said there was an emergent application. Did you say that, Brenda?
Yeah, that's what the comment said.
Okay, so if it's a date for oral argument on the emergent relief, then typically those are decided, the parties, and it's virtual right now, the parties argue, you know, why I should get the stay put and why the student should not get the stay put. There are occasions when testimony is allowed. So I would suggest that you contact the Office of Administrative Law, the judge that is listed, and there should be a telephone number there, and find out if the judge is going to allow testimony, just so you can be prepared one way or the other. But otherwise, it's going to be oral argument, virtually. One thing I was thinking about for parents whose students are aging out next year, and maybe this is something that we can let people know later how to deal with it. But IDEA also has a statute of limitations, which is 2 years from the date you knew or should have known that your child was not getting an appropriate education. So that statute of limitations, I mean, assuming that you knew in March of 2019 that your child was not getting the appropriate services during COVID or in April, you have 2 years from that day to file a claim for compensatory ed. That's going to come up next spring. So I don't think that this statute that we're waiting for the governor to sign, I don't know that changes that 2 year period. I mean, that's something attorneys could talk about and kind of maybe send out something to people. But at this point, I would keep in mind, if I'm asking for compensatory ed back in March of 2020, then the 2 years could be up in March of 2022. So it's something to not forget about. You may want to get that commitment from your district earlier. I don't know, it's complicated. I don't want to raise, I just want to keep, say we should keep it in mind and kind of try to figure it out. If the statute doesn't pass, isn't signed into law, and you're just trying to get comp ed, definitely it's going to be 2 years from when you knew or should have known that your child was not getting an appropriate education.
So we are quickly coming up to the 8:30 hour. We still have a few unanswered questions. We will take 2 more and then we'll move to the kind of advocacy next steps. We are starting to lose a few of our attendees, but this is for Denise. Parent rights, what do you recommend as the most appropriate methods to show progress made or lacking in measurable values?
I mean, so I guess, that really depends on what the goal is or, that you're looking at. So obviously, if you're looking at a child with autism, say, then, and there are skills and they can be measured and there's data. The kids with good autism programs actually have a lot of data. So you can look at those data. For a child, say, with reading deficits, that, you can do standardized testing. I think you need to look at the goals and objectives. I mean, the school district still is supposed to be sending you progress reports on the goals and objectives in the IEP. So if there were things that were not introduced or, not met, and I think just from a logical standpoint, if a student was supposed to learn how to, you know, do a certain task at a job site, for instance, and that job site was not available for a year, then they didn't make progress in that goal unless somehow it was able to be provided differently, although differently might not be the same or enough, because maybe, you know, it needed to be in a public place where, you know, that it's not the same if they did that skill, you know, maybe at their school as it would have been if they could do it in a public place that's noisy and unpredictable. So I think that you have to look at your child and what the goals and objectives in the IEP are and what the deficits are. And you can ask for updated testing if it's relevant to the need of the child, or, you know, any kind of assessments. But some of it is going to be you know, I think I've seen a lot of progress reports that are just, you know, they can't say the child made progress when they didn't give the service. So a lot of it is a lot of NI not introduced all over it. So, I mean, that it is what it is. Again, you know, circling back, like, this has been a very difficult time, and students with special needs have had an extremely difficult time, and their families, and they just didn't get the services they were supposed to get. And now it needs to be made up. I think the bill is a good thing, and I really hope the governor signs it, because it also is a funding mechanism for the districts to provide these services. Because, like we've been saying, regardless of the bill, if the child didn't get the services and needs the services, they're entitled to some type of compensatory education. What that looks like is going to be different in different cases. And certainly the more evidence that you have of what was and wasn't provided and the impact on the student of that and the failure to make progress. And it's not just about regression, although regression can be part of the conversation, because some of the students, it's not only that they didn't make progress, it's also the fact that all this happened, they actually went the other way. So you could be making an argument that not only do they need these services that weren't provided, but now they need more services because of the regression. But on the flip side, the regression itself isn't a requirement. Oh, they didn't regress, because they were supposed to actually make progress. So I think that you want to look at the progress reports, you want to look at the any kind of data the school district has, testing or anything that, and certainly if it's a child with autism, what the data on the programs and the skill development say.
Okay, terrific. And our last question will go to Katherine. Someone says, must you get a stay put in place in order to protect a student if they are graduating and the bill isn't signed until after June 30th? In other words, if you don't, do you lose your right to try and get that additional year?
If you don't file and get stay put, you lose your right to maintaining the status quo, which would be maintaining the current program. You would not lose your right to try to seek compensatory education for the prior loss of services. Rebecca's right. You would have till 2 years from the date that you knew or should have known of the loss, which would be next March. So you can still get the compensatory education even if you don't file for stay put. It just might look different.
All right, thank you. There are still a few lingering questions, and I wish we could get to everything, but we are quickly running out of time. What I want to do before I move us into the next step action items, although you're going to see that up on your screen, is let each of our panelists just do as you did in the very beginning. If there's any issue that didn't get raised or any point that you want to reiterate for families, or a topic that you think needs a little further discussion, I'll just take us right down the line, starting with Liz, Rebecca, Denise, and Katherine in that order. Is there any other sort of closing comments or top level things that you want to make sure that we covered that we otherwise didn't? So Liz?
Okay. Can we cycle through and come back to me?
Yes, absolutely.
All right.
That's going to put you on the spot.
Okay, so I think, and as I was listening to Denise talk about how you show where your child is or the services, what happened when your child didn't get all the services, I think this year parents are in a unique place because you had a very important role in the past 14 months, teaching your child, monitoring your child's education. You know more than most of the school district personnel do about what happened to your child. And I really suggest sitting down and making notes of what you saw, the difficulties you saw your child having, any regression, any loss of skills, lack of progress, and making, you know, a list of that when you observed it and specifically what you observed, because you have so much data yourself if you note it down. So that was one thing I was thinking that I would strongly recommend.
Yeah, okay, thank you for that. That's a really good point. Parents are, you know, you have been the one-on-one para for the whole year. So
right.
You know, you know a whole lot now. Denise, any closing thoughts or high-level comments for folks?
I would just, you know, encourage the child study teams and the parents to try to come together and really discuss the needs of the child and try to work together. I think that a lot of times when these talks of compensatory education take place, when they have taken place in the past, there's always this undercurrent of, you know, you failed my child and thus you owe this child these things. But we're in a very different situation right now where, you know, everyone really did the best they could. I mean, the teachers, you know, many teachers worked so hard to, you know, change over to a completely different method of teaching, and the families did the best they could with work and with trying to help their kids. And it was just a very trying year. And I think that the purpose of this law is to help students with disabilities make the progress they need to be able to, you know, access future adult living and education. And we weren't able to provide that to these students. It just didn't happen because, you know, for the most part, I mean, in different levels, it happened for some kids, somewhat, but no one really got what they were supposed to get since March, since, you know, a year ago from March. So on top of that, we're in uncharted territory. No lawyer is going to be able to tell you if you come to them like, oh, well, if you do this, you're definitely going to get that. I mean, not that we ever can really say that because all these cases are so individualized, but like, there's no law on this, like on precedent of what happens in a pandemic. So it's in everybody's best interest on all sides of this to try to come together for the students and to work together to move past this. And I guess the only other thing I would add is that for the kids that are not graduating this year and graduating next year, and if this passes and they may be able to get another year, that doesn't mean that you would wait until that year to talk about compensatory education. The school district is supposed to start talking about that right when you get back to school. So there may be certain things that could be provided, more speech therapy, more OT, more of things that could be provided also immediately and not just waiting to provide those things the year after. So that would be my closing.
That's a really good point, I think, for the families who have kids that aren't leaving this year, that Comp Ed, you know, we can make up for some of that lost time. We don't have to wait until they turn 21. We can start building in more of those experiences and services. Yeah. Rebecca, did you have something to add? Because if not, I will go to Katherine to close.
No.
Okay. Fine. So Katherine, and then back to Liz.
I think just following up on what Denise said, just remembering that everything still is individualized. The decisions about what kind of compensatory education services or what, if the bill gets signed, what the extra year of services will look like. It's just like it is with every year in doing your child's IEP. It's what that student needs. And And if school district starts telling you that they're only doing X, Y, or Z, as Denise said before, that's treading on very dangerous territory, because that's not how the decision should be made.
All right, Liz, we're back.
All right. You know, I guess I'll just emphasize once more, you know, don't accept a diploma and let your child graduate if you want to try and get additional services. And if you're going to try and do that, you know, you should file for due process before graduation. You can always bring an emergent relief application after the filing of due process to try and invoke stay put. You know, if the law does pass after you file, you might be able to resolve the case with your school district. I'm going to go back to what Denise said about being a lot of uncharted territory, and, you know, things are going to change, and we'll, you know, try and keep everyone updated as much as possible.
Right. So I just can't thank the four of you enough for your legal expertise, for diving into this very unfamiliar area and responding in the moment to these questions, because they are so urgent and so important right now. I'm going to walk us through some action items, and then I'm going to let one of you describe the event one more time that you're going to be doing as a practitioners group. And I will also remind this group that when we do our follow-up email to you, we're going to send information on Alicia's law, which describes walking graduation ceremonies. The Education Law Center's frequently asked questions on Comp Ed with a sample log of how to keep track of that information on how to request public records that came up, the Education Law Center's parents' rights, information about age 21, the section in the code that deals with that. We'll send you a fact sheet, links to both of these workshops. We're not going to leave you after tonight's workshop. We're going to try to continue to provide support and information. So, action. If you are interested in S-3434, make your wishes known. The governor's office will likely be counting and tallying the perspectives that come in. There's a phone number there. Do try to call that number. Again, some of our families have said that when they couldn't get through, they called their state senator and said, I can't get through. So that's the phone call is one place. Emailing the governor's office. If you just Google New Jersey governor contact, the contact form will come up. It's a form that you can fill. We'll ask you to use the topic education. Again, that's a drop-down menu, so you can pick that from your choices. Subtopic is special ed. Again, you can pick that one. Subject line, sign S-3434, if that's what you want to happen. So that is how to take action. We have had some families say that they have taken to social media, and that is another option. I would not say another option, I would say an additional option. Definitely contact the governor's office directly, but you can also go to social media and look for the governor's Facebook pages, Instagram account, and Twitter account. If you want to make sure that his staff are following it, you would use @GovernorPhilMurphy. You can also write letters to the editor of your papers describing how important this is, and there's information about how to do that, probably on your local paper's website. But making the issue public, keeping it in the public eye, and making sure that we continue to keep the pressure on. Some of you have asked about resources. You've said, do I need a lawyer? What am I going to do? This feels overwhelming. Yes, these are some of the materials that we will send out to you. These are some places where you can go for advocacy assistance. And then obviously the upcoming event that the practitioners are doing, and who among you wants to describe that one last time? Looks like Liz has unmuted. And I will ask if you are on this call and you do not want to get any follow-up emails, please indicate that in the chat. Otherwise, we will use your email address to contact you about this event that Liz is going to describe.
Right. So actually, as of right now, it's Education Law Center and Volunteer Lawyers for Justice that I think that'll work together to do this. There's always a fuzzy line with New Jersey special education practitioners because ELC founded and moderated it. I'm moderator of that listserv and very well may pull in New Jersey special ed practitioner members to help with this. But as of right now, we have a planning call tomorrow with BLJ to try and set up early next week. I'm hoping that you can send out perhaps to people once we know exactly when it's going to be, and something that will focus on, if your child is about to graduate and you need to file for due process and emergent relief, to try and walk you through what that actually entails. And really just a little more detailed focus on what you're actually doing and what you can expect to happen, and how you might be able to get legal assistance. Certainly Education Law Center is available to low-income parents in northern and central counties. Limited capacity, we make a lot of referrals to Volunteer Lawyers for Justice, which is why we partner with them a lot. But in any event, we'll figure out what we're going to do and get the information to Brenda by the end of the week to send to everyone, and sometime early next week. We'll just do another information session.
Okay. Great. I'm going to pass it over to Mercedes Witowski. Before I do that, I want to thank Mercedes for your leadership, your courage, your compassion, your tenacity. You wouldn't know it, but Mercedes is up at 6 and stays up until 11 and 12 on this matter, in between running a state agency from a remote location. So you've got a real ally in her, and it is largely because of her that we are here tonight. So thank you for that. And to our attorneys, I just can't thank you enough for the work you do and for volunteering your time to help so many tonight. So Mercedes.
Thank you, Brenda. This is the work that needs to be done, and I'm grateful to have the opportunity to do whatever I can, and through the Council on Developmental Disabilities, whatever it can, to bring you information, to keep you current. Thanks, Brenda, for being on your top game tonight, for getting us through a whole list of questions. I know we left a few there, but trust us, we're not going anywhere. We're here in the long haul with you on this. Denise, Liz, Rebecca, and Catherine, your time, your attention, your expertise, your calm, I think that definitely has me in a better zone tonight. I hope that all of those that were logged in tonight have also experienced your wisdom through the ways in which you thoughtfully responded to many of these questions. I also want to thank the NJCDD staff, Kyoko, Gary, and Maria, for your hands-on, at your computers, making sure everything behind the scenes was happening and is happening. As Brenda said, check the email address that you use to register for this event, for all the events, post information. That is how we will be able to communicate with you. We appreciate your time. We appreciate your advocacy. And we're not going to let go of this until we're over the finish line. So we're here all the way to get you there. Thank you so much. And we look forward to the next steps taking with you.
Thank you, everybody. Good night.